with all that in mind, I'm going to now pass it over to Nick Maraman with the Legal Aid Society, who will take us through our great and informative training today on consumer rights. Nick, feel free to take it away.
Absolutely. Well, thank you, Joey, and thank you guys for joining us on this cold winter morning. I drove into the office so I would have a more secure internet connection, and my lot that I park at near the WHAS 11 building had not been plowed, so I barreled through the snow drift on my little sedan and got through, but at least the roads were not bad. So I'm glad you guys are joining us, and hopefully many of you all are at home staying warm and enjoying the view. I love the snow. Before I share my screen and kind of get into the meat of the presentation, I always just like to give a little bit of background about myself and the Legal Aid Society, especially with everything going on. So I'm a senior attorney at Legal Aid in the Economic Stability Unit. So we practice in 4 areas of law, our unit, which has about 4 attorneys, a paralegal, and a few law students each semester. Number 1, we do a lot of bankruptcy work, which we'll talk about today. Number 2, we do tax assistance with tax law, and I'll kind of talk a little bit about that later. We do consumer debt litigation. So if you're being sued on an old medical debt or an old credit card debt, if you're being sued by a former landlord for unpaid rent, anything like that, if you're being sued for money, we might be able to help. And then lastly, we help with criminal record expungements, which is not the topic of today's presentation, but just want to throw that out there. So I'm from New Albany, right across the river, and went to Wabash College and then to law school at Northern Kentucky University, and decided to come back home. And I now live in the Upper Highlands with my partner, and I've been at Legal Aid for about, I guess, 8 years. So I love Legal Aid. I love the work that we do. I love working with clients, and I like really sharing the type of work that we do with people in the community, because not everybody knows what we do. So Legal Aid is a little bit different than a lot of private law firms. We are a nonprofit poverty law firm. We're different than the public defenders because we don't do any criminal cases. So if you get arrested, we all know that you have a criminal right to an attorney if you cannot afford one. That's when the Louisville Metro Public Defender steps in and helps you. But if you have a civil legal issue, generally there's no constitutional right to counsel unless it's in certain circumstances. So, you know, in family law, if your kids are going to be taken away from you, then you are afforded a right to an attorney. But if you're being evicted, or you want to file bankruptcy, or if you need an attorney in a foreclosure, there's no constitutional right to an attorney. But 100 years ago this year, in December of 2021, the Legal Aid Society was formed, and similar legal aid organizations are all across the country. We receive federal funds and funds from foundations and individuals and big law firms in town, and we have about a $5 million budget and a staff of about 50 people, including about 30 attorneys. So last year we closed nearly 5,000 cases, and as you can imagine, right now we are super, super busy on several fronts, namely evictions. And I know that's a super hot topic. We've got the CDC moratorium, which I believe expires at the end of March. But if you know anybody personally, or you have clients or others in the community who need to reach us, there are 2 easy ways to reach us. The easiest is probably for them to go online. We have a new website, which is just yourlegalaid.org. Again, yourlegalaid.org. And you can click on I Need Help, and you can do an online intake, and then you'll be called by one of our intake paralegals or attorneys, usually that same day, maybe the next day, but we're pretty good about getting back to people immediately. You can also call us. Our number is just 502-584-1254. Again, 584-1254. And if your call is not immediately taken by an intake paralegal, you can leave a message, and again, we'll return your call usually that same day. I think right now, last week when I talked to them, they had a queue of about 20 people normally all day, but we're working through that backlog. And thankfully, we've gotten CARES Act funding for additional money through Louisville Metro. So we were able to hire more attorneys in our housing law unit, more paralegals for our intake unit. because we've just seen an explosive demand in evictions, which is really, really sad, because the last thing that anybody needs right now is to be evicted from their home, A, in a global pandemic, and B, right now when it's 9 degrees outside. So we're working to combat that, because many times people have legal defenses in their evictions and they don't really realize that. And at the very least, maybe we can buy people some time and we can make an arrangement with the landlords so that they get an extra week or two to find a new place, and that they don't get set out. The other thing I would say about evictions, though, is if you get a court date, make sure that you go. And if you don't know when your court date is, or you don't know how to log on to Zoom, call legal aid or call the court to figure that out. There was just a snafu a couple weeks ago where the Zoom link got changed on people, and the courts did not, unfortunately, communicate that very clearly. So we had a lot of people who automatically got evicted because they didn't show up to court. And we're working with, there's actually a community partner of ours who's filed a class action suit in federal court about that, and we're working individual cases. But we just want people to know that help is out there, and that's a big part of what we do. Evictions, foreclosures. We have a family law unit and a personal safety unit, so we do a lot of family law work, divorce, custody. We work a lot with victims of domestic violence, helping to get interpersonal protective orders and domestic violence protective orders to keep them safe. We have several units that are focused on vulnerable populations, the homeless, people with HIV/AIDS, community development that works with nonprofits. So just about any civil legal need that a low-income person would need, we probably have an attorney to cover it. Now, we don't take all types of cases, so there's private attorneys, and we want to keep private attorneys. If people can pay for a private attorney, or they can get their fees, later on in the case, then we're not going to take those from them. So we're not going to do a slip and fall case. We're not going to do a personal injury case. Because there are plenty of private attorneys who will do those and can get a contingency fee if the case is meritorious. So our income limitations generally are below 200% of the federal poverty level, which for a family of one is about $26,000 in 2021. Family of three is about $43,000. I say those are general because we also have some grants that allow us to represent people a little bit above that. So our tax grant, we can go above. People who are 60 or over, we get Title III funds, and we can go, there's no income limitation on that. So we can do wills and powers of attorney for the elderly. But generally, it's below 200% of the federal poverty level. And that means that the vast majority of our clients are the working poor. They might have a full-time job, but they've got 2 children and they're a single person. So they're really struggling, or they're on disability, or they're a veteran, and they're able to work, but they're not able to work 100%. So that's the core of our clients, and we're proud to serve them every day. So I will go ahead and get started on the meat of the presentation, and I'll probably leave questions for the end. So if you could just hold those until the end. So let me go here to share content, and I will go to my PowerPoint. I'll give it a second to warm up, because I know my computer is, okay, there we go. You guys should be seeing this. So let me just go in and start the slideshow. And I try to be as basic as possible on these, because, us attorneys can get really technical and in the weeds if we're not careful. So if it's too basic, I will try to get through the basic stuff quickly. But I just want to make sure everybody is on board and we get all the information out that we want to get out. So today, and I'm double fisting here. I've got my coffee and my water. So we're going to talk a little bit about bankruptcy, the different types of bankruptcy relief available to low-income people, debt collections, Fair Credit Reporting Act, credit reporting issues, something called TILA, which is the Truth in Lending Act, which comes when people are taking out loans for consumer goods. And then we'll talk a little bit about the different enforcement agencies at the federal and state levels that people can contact if they're having issues. We'll talk identity theft. And then also, due to COVID, I'm going to talk a little bit about our tax work and some unemployment issues that we're seeing that are not yet in the presentation, but I just kind of want to go off script a little bit to tell you guys about that. So this is kind of just an overview of some consumer protection laws. I'm not your attorney. This is not legal advice. So that disclaimer has been said. All right. The most common form of bankruptcy that we file for people here at Legal Aid is a Chapter 7 bankruptcy. It's sometimes called a straight bankruptcy or a liquidation. At Legal Aid, we're only filing these cases for individuals, but businesses can also file Chapter 7. So sometimes you'll see that a business has filed a Chapter 7 case, and that's when they're just saying, we're just going to liquidate everything and we're going out of business because our business is not working. The other type of business bankruptcy you might hear about in the news is a Chapter 11 case. GM did it years ago. Toys R Us did it recently. And that's different because it's more of a restructuring. So they're saying, hey, bankruptcy court, we got a ton of debt and our business isn't doing well, but we want to stay in business. We just need to restructure this debt, and maybe we'll pay 15% of this debt. And, the trustee gets involved and they make sure that everything is kosher and everything, but they then emerge from that bankruptcy, and it can take several years or several months. But for Chapter 7 bankruptcy for individuals, that case is usually going to run about 3 to 4 months, and it's going to discharge all debt that is dischargeable, but there are some types of debts that you cannot discharge. So what is a discharge? So that's essentially a court order at the end of the case that wipes out the debts. And what types of debts are not eligible? Well, unfortunately, for many of us, we can't get rid of our student loan debt generally. For good reason. You generally can't get rid of child support. You can't get rid of maintenance and alimony obligations, which makes sense. You can't get rid of a fraudulent debt. So if I just completely screwed over somebody and they sue me for fraud and I get $1 million judgment that I have to pay, I can't then go to bankruptcy court and say, Judge, I want to get out of this even though I completely defrauded these people. So fraudulent types debts you can't get rid of. And then certain tax debts you can't get rid of either. Now, I will say that generally the older the tax debt, and if you filed your return on time, the more likely it is that you can get rid of that debt. But just generally, tax debts are harder to get rid of. And student loan debt, I should have an asterisk there because it is possible to get rid of student loan debt. It's just a very, very high burden that people have to meet. We haven't done a student loan discharge case in years because the burden is so high, and where we are in the Sixth Circuit, the federal circuit where we are that has jurisdiction over bankruptcy cases, the case law is not favorable for student loan debt. I'll talk a little bit in a bit about some current proposals in Congress, but that's the current law. Also in a Chapter 7 bankruptcy, generally the people who file the cases, the debtors, are going to be able to keep some or probably all of their property. I mean, 99% of our cases are what are called no asset cases, meaning that there's no assets that are going to be distributed. In Kentucky, just to kind of give you a sense of some of the exemptions, there's a $24,000 homestead exemption, meaning that if you own a home in bankruptcy and you want to keep your home and you're current on it, then so long as it's less than $24,000 in equity that you have, then the trustee is going to, and the bankruptcy courts are going to say, okay, you can keep your property. You don't have to sell your home in order to pay your creditors. But if somebody files a case in Kentucky and they've got, $50,000 sitting in a bank account, but they're trying to discharge $500,000 of debt, then there are certain exemptions, and they might be able to exempt $12,000 or $13,000 of that if it's just in a normal savings account. But the rest of that, $38,000 or whatever, the trustee is probably going to go after that and take that and pay it pro rata to the creditors, because it's only fair. You shouldn't be able to get out of a bankruptcy scot-free if you have more assets. But for low-income people, generally, we can file the case. They don't have to pay anything because the filing fees are waived. The filing fees are currently about $336 for a Chapter 7 case, but we can get them waived if they're below 150% of the federal poverty level. And 3 to 4 months after the case ends, most of their debts are able to get taken care of and wiped out. And usually also we only have to go to bankruptcy court once or twice. We have to go and meet with the bankruptcy trustee and go over their documents, and he or she asks them a bunch of questions. Of course, that's all being done remotely. So why do we file bankruptcy? Well, we don't do it lightly because a couple of reasons. One is I like to say it's like dropping an atom bomb on your credit report and your credit score. So many of my clients usually don't have very high credit scores or good credit when they come to me, but a bankruptcy is going to make it even worse in the short term and the medium term. The other thing too is you can only file bankruptcy, a Chapter 7 case, once every 8 years. So we want to make sure that people are in a steady position, hopefully with a steady income, hopefully with health insurance or Medicaid, because we don't want them the next day after they file bankruptcy to go out and get a bunch of debt, because they can only file once every 8 years. So the reasons we will do a bankruptcy is to stop a wage garnishment or bank account garnishment. So in Kentucky, if you owe a creditor money and they've sued you in court, they will get what's called a judgment lien from the court. And if you are making more than about $218 a week, they can garnish up to 25% of your wages. So as you can imagine, if you're making $10 or $12 an hour working at Amazon or Thornton's and you're a single mom, 25% of your pay can quickly turn into a crisis, and it can snowball into other crises where you get behind on your car loan and then you get behind on your rent. So if we're seeing a wage garnishment situation and they have significant other debts and the debts are significant, then we'll likely do a Chapter 7 bankruptcy case for them. You know, some people also come to me and sometimes they only have $4,000 or $5,000 in debt. And that doesn't sound like a lot to me as a middle class person with a steady job, but it's a lot to somebody if you're only making $700 a month on disability. I generally like to tell people that usually we'll only file a bankruptcy if they've got about $10,000 in debt, because if it's too little amount of debt, then the bankruptcy judge is just going to say, well, you know, you can get on a payment plan and pay this. And even if you're only making $1,000 a month, maybe you can get on $50 a month and pay it down over the next few years. So that's kind of a general rule, but really, you know, I always take a look at anybody's individual circumstances, because $10,000 can be a lot for some person and not a lot for other people. So it really just depends on the case. The other type of case we will take is sometimes we'll take a case where we remove a judgment lien from a homestead. That's through a process. We have to file a motion with the court to avoid the lien, but sometimes we do that. Also, sadly, sometimes people get really behind on their utilities and they have significant other debts. So we will file a bankruptcy to get rid of utility debt, especially in the dead of winter when you can't get other people to pay for your bills. You know, I know that there's a lot of assistance right now to get people current on their utilities, thankfully, from Louisville Metro and other community partners. You know, I always tell people to seek out the community ministries, family members, friends, if possible, churches, the LIHEAP program, but sometimes that's not enough, and we have to file a bankruptcy to get rid of those debts and immediately turn back on the utilities the day that we file the case. The nice thing, oh, hey, Carol. Carol used to work here as our paralegal, so good to see you, Carol. The nice thing, too, about bankruptcy is something called the automatic stay, meaning that the moment we file the case, a court order goes into effect that automatically stops all collection activities against the client. So that's why when we file bankruptcy, it immediately stops a wage garnishment. And in certain circumstances, we can even get back a portion of the money that's been garnished. So sometimes I have clients who were able to get back a few $100s or maybe even $1,000 or $1,500 that was garnished from them in the 90 days prior to filing. So that's a nice additional benefit because they can kind of use that as an emergency fund going in the future. The other type of case sometimes we will take is people have overpayments of government benefits. So Social Security, food stamps, unemployment. Then so long as that was not based on fraud, so they didn't go to the food stamp office and just say, hey, give me food stamps, even though I'm making 50 grand a year, But if it's an office error or something was just unintentionally omitted, then it's going to be a type of case that we can probably file and get that overpayment fixed and discharged so that they then are not monthly having a portion of their food stamps taken or a portion of their small Social Security check taken or unemployment's not taken 25% of their future benefits. Then the last type of case we take to file bankruptcies for people, and they're not listed here, are driver's license issues. So in Kentucky, if you are driving without car insurance, which is not advisable, but I understand that low-income people and people in certain zip codes, and honestly, there's racial disparities as well on insurance costs. I mean, I have clients who they pay $300 a month in car insurance for a 10-year-old car, and that just seems outrageous to me when I've got a 3-year-old car and it's $100 a month. But anyway, so people who don't have car insurance, if they get into an automobile accident when they're not insured, then eventually they are going to get sued on that by the other person's car insurance company. And those judgments can be very large because you're talking about fixing a car, and many times there's medical bills as well, and attorney fees and court costs and interest. It's not uncommon that those are $10,000, $15,000, $25,000 judgments. And the law in Kentucky says that if you've got that judgment for what's called an unsatisfied civil debt, and it's from a car accident like that, and you didn't have insurance, then the state can take your driver's license unless you get on a payment plan with the insurance company or you pay it in full. So we have clients who don't have driver's licenses and they've got to drive around to get to work and get to the grocery and get to doctor's appointments. So sometimes we will file those cases. And with the automatic stay, the day that we file the case, we can then fax that information to the Department of Transportation in Frankfurt and get their driver's license restored within a few days. So, and then eventually when the case closes in 3 or 4 months, we'll also be able to discharge and wipe out that card debt. The only exceptions to that, rightfully so, is you wouldn't be able to do that, file bankruptcy and discharge a debt if it were based on, drunk driving, a DUI, something like that, which I think for public policy reasons, that makes sense. Okay. The next most common type of individual bankruptcy is a Chapter 13. In Louisville, looking at the case statistics, about 75% of cases are Chapter 7 straight cases, liquidations. About 25% are Chapter 13 cases. So Chapter 13s are a little bit more difficult because that's where you have to set up a payment plan with your creditors and pay them over 3 to 5 years. It's more expensive as well. So if you're using a private attorney, a Chapter 13 case can be up to about $3,800 in Louisville versus about $1,000 or $1,500 for a Chapter 7 in Louisville. But at least in a Chapter 13 case, you can pay your attorney over that 3 to 5 years in a monthly payment. But still, it might be $50 or $60 a month just for your attorney fees, and then a couple $100 a month perhaps in your debts. But it all depends on the amounts of debts you have and your income. The nice thing about a Chapter 13, though, is what's called the right to cure on secured debts. So if you're behind on a secured debt like a car or home, and you want to keep that car or home, then you can file a Chapter 13 bankruptcy, get caught up on your payments, your arrearages in the bankruptcy plan, and then emerge from bankruptcy, be able to keep that. The downside of a Chapter 13 bankruptcy, though, is it's hard to do because you're paying this Chapter 13 plan with attorney fees sometimes. You're keeping your regular bills up to date. I mean, it's just a lot of money. And I think about 50% of Chapter 13 cases fail. And they're just really hard. So, a Chapter 7 is preferable because you don't have to pay anything. But at the same time, Chapter 13, if your income is higher, you're going to be forced into a Chapter 13. And that's kind of for good reason. If somebody is working at Ford and they make $60,000 a year and they have no kids, then they should probably pay some of their debts. So they wouldn't qualify for a Chapter 7 case because it's based on the average income in Kentucky. But if you got a single mom with 2 kids and she's working 40 hours a week at $10 an hour, yeah, she's definitely going to be able to file a Chapter 7 case because she's more income eligible. She's not going to be forced into a Chapter 13 where she has to make payments to her creditors, because we all know that at the end of the month, she doesn't have much, if anything, left over. The guy making $60,000 a year might not be, setting the world on fire, but he's middle class, and he would have to show to the courts why what his expenses are if he wants to try to get out of that. But he's probably going to have to make some payments in a Chapter 13 case. Okay, I will switch over to debt collection and talk about what's called the FDCPA. So the Fair Debt Collection Practices Act is a federal law that protects consumers from, abusive, deceptive, unfair collection practices by debt collectors. This is an industry that is notorious for its abusive practices. And it's a really, really nice law that gives consumers an opportunity to be protected. But the consumer, it's not really regulated by any one agency at the federal or state level. It's really only regulated by attorneys who bring these types of cases. And the nice thing about FDCPA cases is attorneys can get attorney fees if they win. So, there are consumer attorneys in Kentucky who will take these types of cases if they're meritorious. And I think that's kind of nice because there's sort of a private army of attorneys nationwide who will do these types of cases. And if it's really bad and a debt collector is doing something wrong, then they're going to get punished for it, and they're going to have to pay statutory fees and possibly other fees and damages in addition to attorney fees. So it only applies to consumers, and it does not apply to businesses, and it only applies to what are called debt collectors that are due to somebody else. So what do I mean by that? That means that, if Nick Merriman takes out a Amazon credit card and I get behind on my Amazon card, eventually Amazon's going to sue me probably and say, hey, Nick, you didn't pay your $500 credit card bill. We're going to sue you in district court. Well, that's all fine and good, but they are considered an original creditor. That debt has not been bought and sold to another third-party debt collector. So the FDCPA would not apply to Amazon. Now, what's very frequent in these types of cases is these debts get bought and sold by various parties and repackaged as different securities and a bunch of stuff that, frankly, I don't understand. But it means that these are bought and sold, and a lot of these are sold to debt collectors like Unifund, Midland Funding. I mean, there's all sorts of these kind of innocuous sounding names, but all that they do is they buy and sell debts, and then they try to collect from those debts. So those debt collectors are liable under the Fair Debt Collection Practices Act if they're doing something abusive. All right. So what's it do? FDCPA, it limits certain telephone calls. So they can't call you at inconvenient times. So if I say, hey, I work 9 to 5, don't call me during that time, and don't call me at 3 o'clock in the morning, they have to abide by that. They can't call you at inconvenient places. So they can't call your employer and say, hey, legal aid, Nick Merriman's a deadbeat. He didn't pay his Amazon bill and we just bought it. And, Nick Merriman's a real deadbeat, blah, blah, blah. That would be bad. They can't call you at inconvenient places. And they can't call third parties more than one time to obtain your local information. So they might be able to call one time and say, hey, does Nick Merriman still live, at this address? Okay. But they can't just continually call a third party and say, Nick Merriman's a total deadbeat, and he owes us money, and we're coming after him. That would be an unfair or deceptive act or practice under the FDCPA. They can't make statements that are false. They may not harass you. They may not harass you, oppress you, or abuse you. So, that can be threatening language. They cannot claim that we're going to throw you in jail A, because that's just not going to happen, and B, we don't have debtors prisons anymore in Kentucky, and thankfully anywhere else around the nation. So if they call and say, hey, we're about to take out a warrant against you with the sheriff, and the sheriff's going to come and probably lock you up in jail because you didn't pay this debt and you're a deadbeat, no, you need to talk to an attorney about that, because that is clearly harassing you, abusing you, and they can't call 30 times a day at night. If you tell them that you work second shift and you sleep all day, then they can't call you during the day. They can't lie to you about the debt. They can't tell you things that are unfair about the legal process. So they can't say, hey, we're going to sue you tomorrow, unless they actually mean it and they've gotten an attorney and they're going to actually file the case tomorrow. They can't say, hey, we're going to garnish your wages starting Friday on payday, unless they've filed a case against you in court and they've gotten a judgment against you and they know where you work and the attorney's about to file a writ of wage garnishment. So a lot of these things, to be honest, I think that working in debt collection is probably not a fun job. And there's a lot of turnover in that industry because who wants to do people and hound them for their debts? So we do see abusive practices still, even though the FDCPA came out in the 1970s. So just kind of be aware of that. And I want people to know that they don't have to put up with it. All right. So what can you do under the FDCPA? So a few things. You can ask for proof of the debt. So if it's been bought and sold several times, then you can call, say, Midland Funding and say, hey, I did take out a Walmart credit card years ago, and I thought I paid the balance, but I don't really remember because I've moved a few times, and maybe I had my identity stolen at one time by a, crazy uncle. I need you to show me proof. And sometimes they can show you the proof. What we actually find, though, sometimes they can't because they have bought and sold the debt so many times that they can't really give a clear chain of title. So they might have something that says, yeah, we bought a bunch of debts from XYZ company, but there's nothing about Nick Maraman and my Walmart credit card that I didn't pay. So sometimes we can get a case settled on that. You can also tell a debt collector just to straight up stop calling you. So you can only do this for third parties. So I wouldn't be able to call Amazon and just say, hey, stop calling me. But if they sold that debt to XYZ debt collection company and they're a third party, I could just write them a letter, a cease contact letter that says, just stop contacting me. I'm sick of it. I don't want to hear about it. And then eventually people can file a lawsuit against the debt collector if they violate the FDCPA. Many times we bring these as what are called counterclaims. So eventually, if they do sue our clients for the underlying debt and they're doing something that's not right, so like they're threatening clients or, we don't think that there's a clear chain of title and they're still trying to collect on the debt or some sort of abusive practice, then we'll file a counterclaim and say, hey guys, we think you violated the FDCPA and you're on the hook possibly for damages and attorney fees. And that usually will get them shapen up. And many times we're able to settle the case. Of course, it's ultimately the client's decision to settle the case. So they have to make that decision on their own. But it can be a nice litigation tool that we can use to kind of ratchet up the pressure. Now, of course, we can only do it if there's a meritorious claim. So we can't just throw in a counterclaim for FDCPA against every single debt collector. We've got to have an honest, good faith basis to show the court. All right, next I'm going to go into FCRA, which is the Fair Credit Reporting Act. And this has to do all with credit reporting agencies. Some of you guys probably know about this anyway, so I won't go too in depth about it, but just know there's federal law and these CRAs, the credit reporting agencies, are highly regulated by the federal government and quite frankly by the army of lawyers who can take FCRA, sometimes called FCRA cases, because we can get attorney fees for FCRA cases as well. So that's the law, FCRA, that regulates that each of us can get one free credit report each year from annualcreditreport.com. So there's three main credit reporting agencies, Equifax, Experian, and TransUnion. That means that every 4 months, essentially, you could get a free credit report at annualcreditreport.com. Don't go to freecreditreport.com and expect to get a free credit report, because there's probably some sort of thing that says you can get a free credit report, but then we're also going to sign you up for this 30-day free trial at $5.99 a month. So just kind of be careful. Annual Credit Report is the only 100% free one. I know that there are other places like Credit Karma and maybe some other apps that offer free credit reports and free credit reporting, but the official free credit reports are only at annualcreditreport.com. So why is this important? Well, the free credit reports don't have your credit score. So, a lot of clients are kind of like, womp womp, why did I get this? Well, it's important because it's going to show all of your debts and who has them and who is trying to collect on them. So if I had that old Walmart credit card and it got bought and sold to several different third-party debt collectors, and I don't know who owns the rights to collect the debt, then I can see on my credit report who that is. The other thing is that you have the right to dispute or challenge the accuracy of anything on the credit report a couple of different ways. One, you can notify the credit reporting agency of the dispute. You can say, hey, Equifax, they're showing XYZ company debt, but I actually paid that debt a year and a half ago, and I paid it in full, and here's proof of that. Then the credit reporting agency has to do an independent investigation, and they make a determination whether to delete that item or not. You can also dispute it directly with the creditor. So I could write a letter to, XYZ debt collection company and say, hey guys, remember when I wrote you guys that check last year and paid this debt in full? Yeah, I do too. So here's the proof of it, and you guys need to stop doing this. They also have to do an investigation, and they would have 30 days to investigate and then make that determination. If you don't agree with the results of their investigation, that's where you might want to talk to a private consumer attorney to see if you have a good case under the Fair Credit Reporting Act. Some attorneys recommend that even before you send what's called the dispute letter, you talk to an attorney. So I generally just tell people if they've got things that are inaccurate on their credit reports that they might even want to talk to an attorney before they send that dispute letter. Some attorneys like to send the dispute letters themselves. Some attorneys prefer the client send them just for different legal reasons about discovery and whether or not the client then would later have to testify in court about their own letter. And, there's issues about attorney-client confidentiality and privilege. So just kind of want to throw that out there. But FCRA is a really powerful tool due to this. The other thing with the FCRA is it also is going to govern when a criminal background check is used by a potential employer. So as we all know, before anybody gets hired just about anywhere, employers and potential employers are going to do an exhaustive criminal background check. But the thing is, especially with common names or people who have had identity theft, it's not uncommon where there are inaccurate, incomplete, or just frankly wrong things that, hey, this is not the same Nick Maraman. It probably wouldn't happen for me because I have a unique name, but this is John Smith in Louisville, Kentucky. This is not John Smith in Louisville, Colorado, who was convicted of bank fraud. So, I like to tell people that because, you could get an attorney and try to sue them if there's something wrong and it's not corrected. But the big practical piece of advice is if a potential employer does a background check against you and they take an adverse action, like they say, hey, we're not going to hire John Smith because he has a conviction out of Louisville, Colorado, then John Smith in Louisville, Kentucky has the right to challenge that, and he should. You might want to talk to an attorney, or he could write a letter and dispute it, but he would have rights under the Federal Fair Credit Reporting Act, because sometimes they do they don't fix it, and then the job goes to somebody else when it should have gone to you. And that's a case where there would probably be significant damages involved if you can show, hey, I should have gotten this new job and I didn't get it just because they had the wrong guy on a wrong credit, on a wrong background check. The other thing too is with us doing so many expungements of criminal records where a judge removes a criminal record, I always tell people, make sure that all your stuff that's been expunged is not showing up on your criminal background check, because we worked hard to get that expungement. We don't want it showing up and then meaning that you don't get a job, because the number one reason we do criminal record expungements is so people can get better jobs. Okay, a couple things about credit reports. So negative information generally is going to stay on a credit report for 7 years, bankruptcies for 10 years. Tax liens, I think, actually are no longer being reported on credit reports. I recently saw something about that in the last 7 months. I need to update that. But generally, things are going to be on your credit report for a while, so just keep that in mind. All right, next I'm going to switch over to TILA. This is the Truth in Lending Act, which is another federal law, which requires a lot of disclosures when consumers are taking out loans, whether it's a loan for a car, whether it's a signature loan at a bank, if it's a company loan where you're saying, hey, finance company, I want to take out $1,000 loan and I'm going to put up all my furniture in my house as collateral. So important disclosures, and I like just to tell people that they should take a look at these disclosures. They really need to take a look at the APR, the percentage rates, and how much is being calculated there, because you don't want to pay 40% interest rate. You should shop around and try to get a better interest rate. Unfortunately, there are a lot of companies that prey on low-income people with poor credit scores, and I understand that poor and low-income people need access to credit, but I just hate seeing it when people have 25, 30%, 40% interest rates on these loans, because that quickly compounds, and it can quickly turn into a situation where they default on that loan and then they owe thousands of dollars to some creditor. With car loans, there are certain companies in Louisville and just about any city in America that prey on low-income people, and part of their business model is that they will sell a car to somebody knowing that eventually they are going to default on that car. And when that happens with car loans, many of these companies will sue people. So not only when you default on your car, is the car going to get repossessed, but say I bought a car for $10,000 at XYZ car lot, and I didn't have anything to put down, so I financed $10,000, and 5 months later I'm out of a job, so I can no longer pay that payment. Then the car company is going to repossess that car. They are going to sell it at an auto auction, and very often the sale price at auction is nowhere near the retail price that you paid for it. And if they sell it for $5,000 at auction, then they are going to go after me for that $5,000 deficiency and sue me in court. And that means that eventually they could start garnishing my wages and taking money out of my bank accounts and stuff like that. So it's just not a good situation where you've got something where you're dealing with an automobile repossession, because those can quickly turn into thousands and thousands of dollars, or $10,000 or more. And it's just not ideal. Now, if possible, legal aid would try to get involved in that collection case, because a lot of times there's defenses. So maybe there was a TILA violation, or maybe there's a fair debt collection violation if it's now been sold to a third party, or maybe there was an issue with the car and the company didn't fix it even though there was a warranty. So sometimes there's defenses, sometimes there's not, or sometimes people come to us too late and the only thing we can do at that point is file for bankruptcy. Okay, so I'm going to kind of show you a sample disclosure on TILA, and this is going to show you the APR, which is essentially the interest rate plus all the costs, and then it gets combined into the rate, which is why the APR is slightly higher than the interest rate, because it's also going to take into fact other costs as well. You've got the finance charge, which is how much over the term of the loan it's going to cost you. So if it's a 5-year loan and it's at 8.69%, then 5 years times 8.69% is going to be the finance charge. The amount financed is the original amount that you took out, and then the total of payments. So usually there's a little bit of math that we can do to make sure that all of these add up. And surprisingly, actually, sometimes they don't, because the total at the end should be the amount financed plus the finance charge. So, you know, if I'm taking out a loan for a $10,000 car, and the finance car is the finance charge is $2,500, then the total amount should be $12,500. But if that's not the case, then there might be a TILA violation, and we can look into that. The big thing about this is that, you know, customers should look at the rates and shop around if need be. Talk to a credit union, talk to a local bank, see if you can get a better rate. Especially, I would say, if it is a buy here, pay here lot. But to be honest, I say shop around wherever you're buying a car. I mean, unless you're getting a 0% rate with no prepayment penalty, then you should probably shop around. I mean, you know, the big lots and the manufacturers now offer pretty competitive rates, and many times the credit unions and the banks can't compete with them, because the manufacturers are essentially subsidizing you buying a new car. But sometimes you can get a lower rate, so you should find you know, shop around and make sure you're getting the best rate. Okay, CFPB. That is the Consumer Financial Protection Bureau. It's been in existence since the Great Recession, so it's probably about 10 or 11 years old now. And it just is a federal regulatory agency that enforces a bunch of various consumer financial protection laws. The nice thing is they will take individual consumer complaints, they provide financial education, and you can send them a complaint for just about any kind of financial product, because just about any sort of financial product is going to involve federal laws and federal laws that the CFPB regulates. So it could be a mortgage, you know, a car loan, payday loan, any other consumer loan, student loan, credit card, bank account, credit report, debt collection, just about anything you can think of. You can go to the CFPB online, you can write them a letter, they'll do an investigation and give you a timeline for the resolution. And yeah, they're probably not going to wave a magic wand and make it all better, or they're not even necessarily going to go after every single bad actor, but they kind of monitor these things. So eventually, if they say, yeah, hey, we got 50 complaints this year from XYZ about XYZ car lot in Louisville, Kentucky, maybe we need to bring a federal suit against them because they obviously are doing bad things. Then eventually they'll do that, or that they'll go and, you know, sue big banks. And, you know, we saw these huge, monstrous, multi-billion-dollar mortgage settlements after the foreclosure crisis of the Great Recession, because the banks admitted, hey, we weren't doing things right. And, you know, there's a reason why we should have to pay up. And the federal government got a lot of money out of that. And then a lot of that money, frankly, went into a lot of good consumer protection programs around the nation for community groups that were able to help people so that in the future, they would not have these same problems that we saw in the foreclosure crisis. Other things locally, at the state level, Kentucky Attorney General's office, you can file complaints for just about any financial products here in the state as well. Also, like if somebody's having an issue maybe with a contractor, you know, a contractor, hey, I paid a guy to do my drywall, $2,000 quoted, I paid him $1,000 and then he never showed up for the work. Well, you could sue them in small claims court. If you want to, that's one remedy, but you can also complain to Better Business Bureau and the Kentucky Attorney General's office, because like the CFPB, the Attorney General is not going to go after every single bad actor, but they'll monitor these. And if they say, hey, you know, XYZ company in Louisville, Kentucky, it seems like they've ripped off 50 different consumers in Louisville. I think we need to go after them. Then they will. And they'll also go after, you know, the bigger places. You know, I know that right now, Kentucky Attorney General and a lot of the AGs around the nation are suing the what is it, Purdue Pharmaceutical for the opioid epidemic. So I'm guessing that we'll probably get some sort of very large settlement from them. But it's just nice that the Kentucky Attorney General does this type of stuff, because not all of us can sue, um, you know, these places and get the type of results that the Kentucky Attorney General can for us. Also, if you're having issues with like car titles, or things like that, you might want to call or write to the Motor Vehicle Commission and see if that's something that they can investigate. Insurance Commission as well, if you're having issues with insurance, or also private consumer attorneys. All right, ID theft. If you're the victim of identity theft, there are a few things that you should do. One, the AG's office has an identity theft victim kit. So I always encourage people to fill that out, send that in, get a copy of your credit report to make sure that there's nothing on there you don't recognize. Make sure that somebody hasn't stolen Nick Maraman's Amazon card and gone and bought a bunch of stuff and had it delivered to their house, wherever. Notify all your banks, your financial places. If something has been actually stolen against you, like they've used a credit card, some banks will require you to file a police report. I usually recommend, when there's identity theft, to also file a police report, just because, you know, LMPD is not going to investigate every single one of these probably, but at least you've notified them and you've got a record of that. You can also do the credit reporting freezes at annualcreditreport.com, or by contacting the credit reporting agencies individually. You can contact the FTC in Washington, and you know, you also might want to contact the post office if you're having issues with your mail, to make sure somebody hasn't tried to forward certain things without your permission and things like that. So ID theft is real. It happens. You know, not only is it the bad guys on the dark web stealing social security numbers from all the places that we put our social security numbers in, but it's also family members and friends and roommates and things like that, that, you know, people get desperate and maybe they're on substances and they need money. So it's a crime of opportunity if they see your credit card statement there, or your credit card there, or your social there, and then they apply for something in your name. It does happen. So just want to kind of tell you guys about that. All right, before I finish up, I know this is a 2-hour presentation. I won't go all 2 hours. We'll leave plenty of time for questions. Here's my contact information. The easiest way for advocates to get a hold of me is to email me. I can give you all my direct phone number at the office, because that's just our general line. My direct line at the office is 502-614-3190. Again, 614-3190. And but email is usually the easiest way to reach me, but you can always give me a call if you've got something that you want to discuss. And before I turn it over for questions, let me kind of just talk a little bit about unemployment, student loans, and taxes, which I know are everybody's favorite things to talk about. So first of all, student loans. I just like to tell people that student loans are really, really complicated. And I wish that there were like a one-stop shop in every part of the country where people could just get free student loan counseling. But I don't see that right now. So if people have legal questions about student loans, like if they're getting sued by a student loan company, then that's something that legal aid could step in and potentially represent low-income people in a student loan collection case. But a lot of student loans are federal loans, meaning that you can get on what's called income-based repayment plans. You can consolidate your loans generally once to get a lower interest rate. And the thing is, with student loans, if you don't know who your student loan servicer is, and you don't know who you owe the money to, you can get something called the National Student Loan Data Service Report, the NSLDS report. So if you Google that, or if you go to studentloans.gov, you can get online and get that report. And what it's going to show is all the student loans you've ever taken out in your lifetime, and who currently holds them and what the balance is. So, you can't just call Department of Education and say, hey, who do I owe? I mean, they can look it up, they can figure it out, but this is going to give you all the information that you would need and see if you've consolidated it, etc. The other thing about student loans is right now we're seeing a lot of private companies that are offering you to consolidate your federal loans into private loans. I tell people to approach those with extreme caution, because yes, federal student loans have high interest rates, 6 or 7%. They're not good, but they also have federal protections with them. So if you get sick or you lose your job, you can get on income-based repayment or go on a forbearance. And many times, if you don't have any income, you would pay $0 a month. I don't think that these private programs have those same opportunities. So if you refinance $50,000 in student loans with XYZ student loan company, then if you lose your job the next month, they're probably not going to care. And to be honest, if you don't pay for months, they're probably going to sue you. And because you can't get rid of those in bankruptcy, that means that eventually you could get garnished for those, and you could be looking at a garnishment that lasts years and years and years. So student loans, because they are unique in that they can't be gotten rid of in bankruptcy, I say especially approach those refinancing places with extreme caution. Now, I understand some people, they're going to plow through their student loans if they're making good money and they're sure they're in a job where they're not going to get laid off, and they want to save 5% on their interest rates or whatever percent. I get that, but I say extreme caution. Unemployment. So, at the beginning of the pandemic, we had hundreds of thousands of Kentuckians applying for unemployment insurance. And as you can imagine, that has caused a ton of problems. We still have people who are waiting on their unemployment, even though they applied last summer or last fall. Legal aid does now have a contact in the governor's office where we can elevate claims, but just want to kind of point that out. The other thing with unemployment is, because it is a governmental benefit, if you're denied it, then you have certain appellate rights. So if you're originally denied, you can appeal that and ask for a hearing before a neutral hearing officer, also called a referee. Your employer may or may not choose to attend that phone hearing, and you have the right to an attorney to be there as well. If you lose that, you can appeal that decision to the Kentucky Unemployment Insurance Commission. If you lose that, you can appeal it to the circuit court in the county in which you work. So, we've done some of those appeals. We have some volunteer attorneys who are also doing those phone hearings. Just want to kind of get the word out about that. Now, there are deadlines. Usually it's 15 days from the date of the mailing of the decision. So you want to make sure that you act on that quickly and don't just say, oh, well, I'll call legal aid on the 14th day, because we might not be able to help you at that point. Or we might say, hey, if your hearing is tomorrow, we won't be able to be there because we're going to be in court, but at least we can provide you some advice and kind of point you in the right direction. The other thing with unemployment is they've had a lot of fraudulent claims where people on the dark web have stolen their information and said, hey, I'm Nick Maraman, here's his social, now give it to me at this account in California. And then I might get my 1099 from unemployment in January, and it says Nick Merriman got $12,000 in unemployment. And I say, hey, unemployment, this wasn't me. What the heck? There is now an email address that the state has set up so that people can notify the state if they've got fraudulent claims. I would encourage people to also file a police report on that, just to make sure that there's any and all evidence. And then the state should be reissuing those 1099s so that they're correct. But if there's a tax issue with it, that might be something that we or somebody who does taxes could help with. So that's unemployment issues. And then last, because it is tax season, the tax filing season officially started last Friday. Just kind of want to tell you about some community resources. You probably know about Louisville Asset Building Coalition. Their website is labcservices.org. Again, LABC for Louisville Asset Building Coalition services.org. They are the IRS trained and certified free tax preparation volunteers in Louisville Metro. AARP Tax Aid also does free tax return preparation for people, I believe, over 60. The VITA sites are for anybody below $66,000. So that's a great opportunity and resource for people. I always tell clients, why pay $100 or $150 to a private tax return place if you can get it done for free? And also the LABC is not going to do refund anticipation loans. So, those are loans where private companies say, hey, it's going to be 2 weeks before the IRS deposits your tax refund. How about we go ahead and give it to you today? Well, that's all great and well, but if you take a look at the interest rates, they're astronomical, and I like to prevent people from going into those if they can. Now, I know in certain circumstances, people are going to make that decision and personal decision, but I just want them to know that there's other resources out there. The other thing is legal aid. So we have what's called an LITC, which is a low-income taxpayer clinic. We provide free civil legal tax help on tax law issues. So what does that look like? Well, if you get an audit from the IRS, we might be able to help with the audit. If you're what's called an innocent spouse, you don't think that you owe this money because it's just your ex-husband that did it, that he didn't report his income on his business, then we can help out. We help out a lot with just IRS debt collection issues. So if you got a tax refund and then later the IRS said, hey, we want that tax refund back, so you now owe us $5,000, then that's really an issue for low-income people, because the IRS is going to keep taking your tax refunds until that balance is fully paid. And the IRS is also the largest collection agency in the world. They can threaten to garnish you or threaten to take your home, and actually. So there's a lot of collection alternatives and things we can do, especially for low-income people, to try to offer a compromise or try to get them on a hardship forbearance, and try to get them in a place so that they are not just being hounded by the IRS and not getting stuff garnished from their pay or levied from their bank accounts, because we don't want that to happen to anybody. Injured spouse offset bypass refunds, just kind of want to point that out, that if your refund is being offset for something and it's due to a back owed tax debt, so Nick Maraman owes $5,000 in tax debt, and he's getting a $2,500 tax refund this year, well, the IRS is going to take that. But if I can show the IRS that I have an economic hardship, like, hey, I'm $2,500 behind on my rent and I'm going to be evicted tomorrow, then they will actually offset that debt, and that $2,500 would go to me. But I've got to document it, and I've got to show severe economic hardship. The other thing I'd like to point out is something called the Taxpayer Advocate Service, or TAS. So Taxpayer Advocate Service has an office in Louisville at the Federal Building. Of course, they're not there, so don't go there right now because everybody's working remotely. But that is a service that if you have gone through normal IRS channels and you just need somebody to help cut through the red tape, the IRS has said, hey, we still haven't gotten to your case, and it's been months and months and months, then you might be able to call TAS and they might be able to help you cut through the red tape or make a decision or ask the IRS to make a decision faster. They can do a lot of things like that. They do a lot of ID verification on tax refunds. So, if you've got to verify your identity, you might have to go through Taxpayer Advocate Service to get that, to make sure that you get that tax refund. So Legal Aid is out there. The VITA sites are out there. Taxpayer Advocate Service is out there. I like to point that out, especially around this time of year, because so many low-income people, the tax refund is such a significant portion of their income that we want to make sure they get everything to which they are entitled. So I think that is all that I have in terms of my presentation, and then I'll kind of take questions or talk about anything randomly that somebody wants to ask me about.
I have a question. Can you hear me, Nick?
Yep. Go ahead.
Can we get a copy of your presentation? Is that possible?
Yes. I have emailed it to Joey, and he can forward it to you guys, or you can email me for it, whatever's easiest for you all.
Yes. Yes, it will be
Okay.
sent out after this class.
Okay, great. And then my next question is, can a debtor, if you had, I guess, a hospital bill or some kind of debt, and you think you may have paid it 10 to 12 or 15 years ago, and they come back and garnish you or send you a letter, but you can't find your documentation, can they still collect on that after that many years? Or how do you?
I hate to say this, but it depends. So it depends really on where the case is. So if they've already sued you and gotten a judgment against you and they're garnishing you now, then it's probably going to be difficult for us to try to tell the court, ask the court to undo that. It's a really high bar. We can try, but it's a high bar. Now, if they just have started suing you, then yeah, I mean, we could in the discovery process ask them for all their account information going back 10 or 12 years, and they should have a record of that, even if you can't find it. Sometimes we might be able to subpoena your bank records and get your bank records from back then, even if you don't have them or you don't have online access to them. Or we can do a demand letter before we send a subpoena to try to get it from the bank. So yeah, there are some options, because we wouldn't want anybody who legitimately has paid their bills to later get sued on it. And if it's a third party creditor, then they could be subjecting them to additional liability by breaking federal laws if they're knowingly doing that.
Okay, and my last question is, currently, the student loans, are all of them on hold due to COVID, or can you?
Yes. I meant to mention that. So currently, my understanding is all federal student loans are in a temporary forbearance, and I think that it goes through the end of September, and that was automatically placed. If you have questions, you can contact your servicer about it. The one exception to that is apparently there are some federal loans that are, quote, commercially held by the Kentucky Higher Education Assistance Authority that were not covered by that executive order in Congress. So I think that there have been proposals to cover those. They're called either FEL loans, FFEL, or maybe even Perkins loans. So they're older loans from like before 2009, 2010. And I think Congress is trying to rectify that, and we'll see if in the new COVID relief bill, if that ever gets done, what happens. But yeah, right now, the vast majority of student loans should be on hold and not accruing interest. Now, if people want to make voluntary payments on those, they absolutely can, but they wouldn't have to right now.
Thank you.
Yep, good questions. Carol, do you have any questions? It's good to see you, or good to see your, not see you. If she's listening, she might have turned, she's used to tuning me out.
All right. Any other questions for Nick?
I have a quick question.
Yeah, Jennifer.
Yes. So how do you determine your eligibility? So yeah, given that there's issues with people's historical income and their recent income.
So we, we go by what people tell us, so we don't have to provide. They don't have to provide proof of their income, but generally, we think that people are, going to be honest with us. So we go by their current income. So if they've just lost a job and they used to make $50,000 a year, but now they're making $0 a month, then yeah, they're probably legal aid eligible. So with the unemployment cases that we've been taking on the last few months, we've had a lot of middle class people who are no longer middle class and thought, yeah, in the past I would never be eligible for legal aid, but now I am. So we go with their current income, whatever that is. If later on in the case, if they get a new job and they're making a lot of money, then at that point we might have to withdraw. We would have to look into it at that point. But if it's would be adverse to the client, then we wouldn't do that. So we would see the case through. So, if we file a bankruptcy and discharge is going to come tomorrow and you've gotten a job the day before, then yeah, we're gonna see the case through. But generally we're not representing people who have a lot of money. We're only representing people who really are needy and can't afford an attorney.
Great, thank you.
Yep.
All right. Any final questions? All right. So it sounds like there are not any. So, of course, as always, we'd like to thank Nick for taking time out of his day to provide this very useful class and this information.
I'll take my bow.
As I mentioned, I will be sending out the PowerPoint and a post survey later today, so everyone will get a copy of that. Our next available classes coming up are on March 12th. It's a Rare Friday session on working with SSI and SSDI with a representative from the Center for Accessible Living. That's from 10 a.m. to noon. We also have another one in March on the 23rd from 10 a.m. to noon, a Train the Trainer on some different financial education curriculums in the city of Louisville. You can register for all of those like you did this one on the CNPE's website. If you need to contact me about any certification program questions in general, my contact information is joseph.cecil, C-E-C-I-L, at louisvilleky.gov. I will put that in the chat. Or 502-574-1969. Those are both in the chat. Again, that's joseph.cecil, C-E-C-I-L, at louisvilleky.gov, and 502-574-1969. If there are no further questions, I believe we are all good to go, and we are finished for this class.
Thank you.
Thanks, everybody. Take care.
Bye-bye.
Thank you.